New Clause 1, funder of the last resort.
The question is that new Clause 1 be read a second time. Ian Blackford.
Mr Deputy Speaker, I rise to move new clauses 6, 7, 8 and 9, as well as amendments 5, 6, 7, 8 and 9. Mr Deputy Speaker, there is much in this bill that I would commend. It rightly introduces regulation for master trust and will help shape confidence in pension savings, particularly for auto-enrolment. As at the committee stage, we sought to work constructively with the Government to bring forward new clauses and amendments that sought to enhance the bill, as well as was dealing with other shortcomings in the pensions landscape appropriate to the bill. Mr Deputy Speaker, I am disappointed that new clauses 10 and 11 were not selected for debate. The Minister knows that my view that in the landscape of pensions and saving that my approach is to work constructively where we can to encourage consumer participation, and whilst there is much elsewhere in the field of pensions that I would like to see enhanced or greater clarity delivered on, I would congratulate the Government and in particular the Minister for bringing this bill forward. This bill builds consumer protection for master trust and is an important step forward in enhancing the appeal of auto-enrolment. We will, of course, be reviewing auto-enrolment later this year, and it is important that we take the opportunity of this legislation to make sure that we have the appropriate regulatory steps in place. I would encourage that when we do review auto-enrolment, that we look positively at how we can substantially take auto-enrolment forward for part-time workers, those who have been excluded, many with multiple jobs, particularly women, as well as the self-employed, charting a way forward that builds pension entitlement, hopefully in a way that builds consensus, perhaps avoiding, if I may say so, the screeching U-turn that we saw from the Minister's colleague, the Chancellor of the Exchequer, in recent days. Mr Deputy Speaker, this is a serious subject, and this bill should be seen as part of a wider debate as how we increase pension savings, building trust in the pension savings industry. I was struck to read in the Government's Green Paper on defined benefit schemes published last month that the average defined benefit scheme payment is as little as £7,000 per annum. We also have a research paper from MetLife this week highlighting income challenges threatening pension freedom, as well as a paper from the Centre for Policy Studies, which, amongst other issues, raises challenges around drawdown. It is clear that collectively there is more to do to encourage trust and confidence in pension savings, and in particular that all are encouraged to save at an appropriate level to secure dignity in retirement. It is on that basis that we on these benches will work constructively with the Government on this agenda. In the meantime, this bill is a welcome step forward. I hope that, in a spirit of engaging positively, that the Minister will give careful consideration to the new clauses and amendments that I and my colleague for Paisley and Renfrewshire South have tabled. They should be seen as clauses and amendments that seek to improve the bill. They are not in any way, shape or form wrecking amendments. Let me start with new clause 6. This new clause makes provision for the Secretary of State to restrict exit fees paid by Master Trust scheme members. It is not clear to us why Master Trust members should have to pay any exit charges. It is welcome that the Government are placing a 1% cap on exit fee for current members and no exit fee for new members. However, why the threat of exit fees for existing members? We know that large fees have been charged on exit in the past, and it is clear that we need to protect savers. I asked the Minister to confirm at earlier stages that there would be no exit fee for an individual leaving a Master Trust. The Minister responded that when a Master Trust was closing, it could not levy a charge, but I would appreciate if it would make it explicit in all cases that fees should not be levied. As far as new clause 7, 8 and 9 are concerned, new clause 7 would require the Secretary of State by regulations to make provisions to amend Section 75 of the Pensions Act 1995 in order to protect unincorporated businesses, those that are at risk of losing their personal assets, including their homes. New clause 8 would require, within 6 months' calendar time from the date in which this Act comes into force, the Secretary of State must conduct a review of the actuarial mechanisms used to value pension schemes' liabilities under Section 75 of the Pensions Act 1995. And new clause 9 would compel the Secretary of State that must by regulation exclude from the calculation in Section 75 of the Pensions Act 1995, the orphan debt and any non-associated multi-employer scheme. Mr Deputy Speaker, these amendments would help deal with the current issue facing plumbers in Scotland. Plumbing Pensions UK Limited was established in 1975 to provide pensions for the plumbing and heating industry UK-wide. The scheme is managed by a group of trustee directors appointed from nominees of the Association of Plumbing and Heating Contractors in England and Wales and SNPF in Scotland and United Union. The scheme has over 36,000 members and assets in excess of £1.5 billion. Under Section 75 of the Pensions Act 1995, employers can, in certain circumstances, become liable for what is known as a Section 75 employer debt. The debt is calculated on a buyout basis, which tests whether there would be sufficient assets in the scheme to secure all the member benefits by buying annuity contracts from an insurance company. Legislation specifies that a Section 75 employer debt becomes payable when the employer either becomes insolvent, winds up, changes its legal status, or ceases to have any active members in the scheme. Whilst we must be mindful that the purpose of these rules is to protect pension benefits, however, the way they are currently framed creates problems for some stakeholders. We are sympathetic to the concerns raised by SNPF. I'll happily give way.
Thank the honourable friend for giving way. Does he agree with me that it's because of such examples as those he's already touched on of unincorporated businesses at risk of losing their personal assets that it's so pertinent right now as to why the government has to bring forward a solution now rather than wait for the opportunity to pass?
I'm very grateful for my honourable friend, and she's absolutely right. I mean, these are complex issues, and that's why that we make the suggestion from this side of the House that we're willing to work with the government on this. We have to find a solution to this, because at the end of the day, ordinary people that have done the right thing are now being faced with losing their house, and that cannot be right. So it's an issue that has to be resolved. There are a number of options for the government to consider, but each one has complications for the pension schemes, employers and scheme members. We would urge the UK government to weigh up the interests of employers with the need to protect benefits for pension schemes. Mr Deputy Speaker, the former Pensions Minister in the other place, Baroness Altman, indicated that she would look closely at how a solution could be reached to this complex issue. We need the same assurances from the Minister that he will work to find a solution for the industry and should use the introduced pension scheme bill to bring forward a solution. Mr Deputy Speaker, SNPF's 4 objectives are to achieve an amendment to the Section 75 debt legislation, as their main concern is for unincorporated businesses, as my honourable friend has mentioned, who are at risk of losing their personal assets, including their homes. For government to conduct a review of the actuarial methods used to value pension schemes' liabilities, as they believe that the calculation of Section 75 employer debt on a full annuity buyout basis is inappropriate and detrimental to non-associated multi-employer schemes given current economic circumstances. They argue that orphan debt in any non-associated multi-employer scheme should be excluded from the calculation of Section 75 employer debt, and they suggest that provided the scheme is deemed to be prudently funded, that the PPF acts as guarantor of last resort for orphan liabilities. They also believe that any changes in legislation should apply retrospectively to all employers from 2005. It would be helpful to get the government's view on this request. Mr Deputy Speaker, SNPF met recently with the Minister, and they have advised SNP MPs that the Minister confirmed that the objectives may have been incorporated within the Green Paper. We are interested now to hear the Government's view as to whether or not it has identified a solution. Very briefly, I wanted to make passing reference to my 2 new clauses that have not been selected for debate, and I wanted to signal my disappointment and indeed put this on the record. Firstly, beginning with new clause 10. This new clause would require the Secretary of State to identify support for women affected by the changes to the timetable for state pension age equalisation. We are disappointed that a pension bill has not been brought forward to deal with this pressing injustices within the pension system.
Give way on that one.
I'll happily give way.
Thank you. Does the honourable member agree with me that by missing this opportunity, the government are actually willfully ignoring this opportunity, much like they're ignoring the WASPy women themselves?
Maybe I And what we don't do is discuss clauses that we've not chosen. We've got to deal with what's before us, and that's the clauses that are on the order paper. And I know you want to stay in order by dealing with the present ones, not the ones that have been omitted. Ian Blackford.
Thank you, Mr Deputy Speaker, and I'm happy for the guidance that you've given me. I simply just wanted to put on the record that we have missed the opportunity today, and I hope and I know that we'll have the opportunity to raise this issue again. So I'll skip on from making any further reference to these two issues. The SNP believe we need to look holistically at the inherent problems in the system and build on new opportunities such as auto-enrolment. Only by giving pensions thoughtful time and consideration can the government get this right. With alarm bells ringing over the injustices facing the WASPI bill and concerns that we could see another hike in state pension age, even the contemplation that the triple lock will be reviewed post-2020 is deeply troubling. We know that, if I may say so, that by delivering an independent Scotland we can deliver the dignity in retirement that so many of our pensioners would need. Let me turn to Amendment number 5. This amendment would mean that the financial sustainability of a scheme funder must be taken into account when assessing a Master Trust scheme's financial sustainability. The ABI have told us that insurance companies already hold a very significant amount of capital under the European Regulatory Framework for Insurance Solvency II. And in our view, it would not be reasonable, nor is it necessary, for insurers to be required to hold separate or additional capital on top of this in order to meet their new obligations as Master Trust providers under the bill. We would like to hear assurances from the Government that insurers will be exempt if they already adhere to FCA and PRA regulatory and financial sustainability requirements. As far as Amendments 6 and 7 are concerned, Amendment 6 allows for exceptions to the requirements for scheme funders must only carry out activities directly relating to the Master Trust scheme for which it is a scheme funder. Amendment 7 makes provision for the Secretary of State to define restricted activities by regulation, including a list of specific activities restricted in order to minimise the loss of Master Trust scheme funders. These amendments acknowledge that there must be circumstances where the scheme funder requirements within the bill should not apply. They state that the requirements need not apply to firms whose activities are already restricted by virtue of the existing regulation. The ABI have said in particular the Prudential Regulations Authority rules mean that insurers' activities of the scheme funder not directly related to the Master Trust scheme are transparent and do not threaten the solvency or sustainability of the Master Trust. The ABI have said this is sensible and a pragmatic approach. It would be useful to understand what additional requirements will need to be met for firms to be exempt from the scheme funder requirements. It would also be helpful to gain assurance that the Government is committed to working with the industry throughout the development and consultation process for the regulations. As far as Amendments 8 and 9 are concerned, these amendments provide the pension regulator with an alternative to stopping payment to the scheme under subsection 5b of a pause order. Amendment 9 is consequential to Amendment 8. The bill creates a new power enabling the pensions regulator to make a pause order requiring certain activities to be paused once a trust has experienced a triggering event. This includes accepting new members, making payments, accepting contribution and discharging benefits. We are concerned about the impact of a pause order on a member's saving, as there is no mechanism in place to allow ongoing contributions to be collected and held on behalf of a saver. We would contend that this is unacceptable, that a member be penalised for no fault of their own, and in effect lose wages in the form of employer contributions due to events outwith their control. The Society of Pension Professionals have also said that it will be necessary to ensure that the period of effect of a pause order cannot start before the trustees actually receive notification of the pause order. This would then mean that any controversial order could only occur after the trustees are in receipt of the order. Without this, they argue that the trustees could be in breach of a pause order through no fault of their own if a direction is not complied with during the period between 1. the date that the regulator makes the order, and 2. the date the regulator notifies the trustees of it. For example, if new members joined the scheme in that period contrary to direction under clause 32(5)(a). The Government should clarify if they intend to take action to protect savers now, as we are disappointed that our amendments were defeated at earlier stages. Mr Deputy Speaker, I look forward to hearing the Minister respond. We have sought to work constructively with the Government to enhance the bill that we have in front of us today that we broadly welcome. We affirm our position of wishing to work with the Government where we can to create an environment where workers can have faith and trust in pension savings. We all should have a desire to develop the landscape where pension savings are seen and are encouraged, allowing us to achieve a situation that all our pensioners, from both their own provision and through the state pension, can have dignity and security in retirement. This bill helps us along that road as far as regulation of master trust is concerned. There is more to do to enhance auto-enrolment, and I look forward to working with the Government to take steps to include those currently excluded from pension savings, particularly the self-employed and many part-time workers, particularly women. In closing, whilst I welcome this bill today, I also reflect on the necessity of having had to put down a praying motion last night on the issue of frozen pensions, after the Government has again brought forward a statutory instrument to freeze the pensions of hundreds of thousands of British pensioners who have been denied their rights. In pushing this instrument through, the Government have denied the right of members of this House to debate this matter. I encourage all honourable members and right honourable members to sign EDM 1097, and as I believe we can demonstrate broad cross-party support against this measure, the Government will have the grace to bring forward a debate on this matter before recess. This EDM has been signed by members from 6 parties, including the Government. I would encourage the Government to listen to this matter as part of the process of the bill today. Thank you.